Okay, I forgot. Yes.
For judgment, item number 1.
This is that NDPS, right? Here what I have done, Miss Mary is not there. Here I have acquitted the... Here I have... You are there in this matter?
Yes, madam.
Okay. You are there in this NDPS, right? No, the NDPS matter.
It's POXO case matter, my lord.
Her POXO case is next. I think this is what?
Item 1
this
is the POXO matter.
Okay. POXO, I have acquitted the appellant. Mainly on the ground that the girl, the statement of the victim was not, she cannot be termed as a sterling witness because there are so many discrepancies on that. And even medical evidence, what I found is the examination was ordered by the IO after the case was registered. The medical examination, right? But then the medical examination report shows that she was examined the day before, 20th. 21st, the FI was registered. So there is doubts, yes, as to whether it was. So in those grounds, I have acquitted. Of course, he is inside in the other case, I think, which is there on board today. If he is not required, so he is to be released.
Item 2.
This NDPS case, right?
Madam.
And this is also, I have acquitted him mainly on the grounds that the contraband, the safe custody of the contrabands could not be proved, mainly because there were so many days of delay. Not delay, but then in whose hands, in whose custody, where those were kept during those 5 days period. Mainly on that ground, coupled with
Yes.
the non-production of the Malkhana register,
Yes.
as well as the violation of 52A.
My lord.
Because although Mary had shown that judgment, any one of the procedures or
Yes.
can be followed in 52A because
Yes.
of the word or.
Yes.
But then I have seen other judgments where it is said that all the three are mandatory requirements and they become primary evidence. And if there is no primary evidence, then it will vitiate the trial.
My lord.
So in that case, I have acquitted this person
I'm deeply obliged.
in view of this.
I seek your lordship indulgence in making mention. Hearing
Yes.
list item number.
Which matter?
Hearing list item number 2.
Hearing list item
Number 2.
2.
Yes.
Why, it is fixed today, and the same person,
Yes.
right, who got acquittal in that particular case today.
Yes, my lord.
So
Your
now
Lordship,
you are not doing this item number 2. When do you want?
If the matter can be taken on Thursday, I'm taking the consent of the state VP.
Thursday.
Thursday.
Okay, we'll give a try. But why not today? Do it today.
Your lordship, my senior has some personal difficulties.
Senior means
Long is Fanai.
Fanai.
Yes.
Okay. Right, in item number 2, Mr.
Elias Laram Chuna.
So and so, learned counsel appearing for Miss Langhai Shaki Fanai, counsel for the appellant, submits that the conducting counsel has some personal difficulty today and as such has prayed for some adjournment, has some accommodation. Prayer is allowed. List the matter on Thursday,
7th
on 7th
August.
7th August, as prayed for by the council.
That's obliged.
Daily list for admission, item number 3.
Miss Mary, you are here. I had acquitted the appellants in both the cases.
Yes.
In the NDPS case, what I found is the contrabands were not in safe custody because there was...
Yes, 5 days.
For 5
Yes.
days especially. Even if we consider 26th, it was in the Malkhana. But then
Yes.
the other days is not accounted
understand,
for.
yes.
Coupled with not only that ground, coupled with Malkhana register not produced, as well as of course you have shown the judgment that the word used is or in 52A. But in the subsequent judgments I've got that these are mandatory, all three.
Yes.
The Supreme Court has said all three they become primary evidence and in absence of that vitiates the trial. So on these 3 grounds
Okay.
I have acquitted.
I
And
understand.
even in that POXO case also, because the girl's statement differs from here to
I
there.
know.
And then let's see if it goes to the Supreme Court.
Inconsistencies, yes.
But then yes, it differs. And then also the medical evidence, what I saw is the examination was ordered after the case was registered by the IO. He had also said, I have sent the victim. But in the examination report was of a day prior, of 20th. 21st the case was registered. So there is doubt.
Yes.
So in those grounds I have acquitted. Yes, item number
Item
1.
3 for admission.
Yes, 3.
May I please, Your Lordship?
Huh.
My Lord, the matter pertains to land acquisition proceeding. And my Lord, recently, there is in one analogous case, this court had passed an order. This, Your
I
Lordship,
think
may kindly see-
by the last order, Miss Mary was supposed to place some compliance
Yes.
report.
Yes, my Lord.
Your Lordship, as far as my who I represent is concerned, we have already filed an affidavit, and then after that, the DC have made a reassessment, and then in the reassessment, it is already approved by the government. I can produce the letter.
In the same line, my Lord, that reassessment was already approved by the state government.
Yes, it's already
And thereafter, that has been sent to the Central Acquiring Authority.
Just
And-
a second, just a second.
Yes, my Lord.
Just let me go through. I forgot.
So what happened is that
Okay, yes.
in this case, a word is made. A word is made, but then the acquiring authority have stated that correction needs to be done. And then they have sent back the award, approved award. And after going through on perusal of the records, they have found that yes, correction needs to be done. So they have made a reassessment in the latest steps in which in the affidavit, show cause reply affidavit, which I have filed on behalf of respondent number 10, which goes on to show that it was sent to the Land Revenue and Settlement Department for reassessment. Now, Your Lordship, the Land Revenue and Settlement Department have again approved on 5th June 2025, which I have
Yes, yes.
produced. And a copy is
Otherwise,
already,
the fact remains that the land is acquired.
is-
Because the order was if it is not acquired. If it is acquired, then do it properly under the 2013 Act.
it's under process, Your Lordship.
Acquisition is under process.
It's under process. And Your Lordship, the approval, the reassessment approval is given to the concerned acquiring authority, which you can see in the copy 2, serial number 4. That is the Chief Engineer BRTF Pushpak. Now, Your Lordship, in the similarly situated case, my learned friend will be placing an order. Order is already passed in this regard.
No, what I mean to say is that, my Lord, the learned
Otherwise,
CGC
you are satisfied, but otherwise, there is a time limit given.
That is correct, my lord.
Acquisition within 6 months. Acquisition and compensation to be paid within 6 months. Of course, that is gone. But then, what do you say? You
My
are-
Lord, Your Lordship may kindly see the order of contempt case number 25 of 2019, which I just placed before Your Lordship.
Acha, acha. In a similarly situated contempt
Another case,
petition?
my Lord.
Yes.
The CGC Acquiring Authority were asking for 6 weeks' time for payment. So time was granted in that case. Until then, if Your Lordship may kindly see the order which I placed before Your Lordship.
What?
If Your Lordship may kindly see the order which I placed before Your Lordship.
Just show me that judgment, what was
I
done.
just,
Order here.
I have
Oh,
just
acha,
placed
acha. The one you have given?
contempt case number 25 of 2019.
Yes.
This is order dated 21/7/2025. My Lord, from para 6, my Lord, kindly see from para 6.
Yes.
Today, when the matter was called, Mrs. Learned CGC, Mizoram appearing for the respondent, submits that she has received an instruction dated 21/7/2025, which indicates that the reassessment has been completed by the concerned department, and after the reassessment was completed, the Under Secretary of the Government of Mizoram, Land Revenue and Settlement Department, on 29/5/2025 approved the award number 12 of 2024, amounting to rupees such and such for the construction of the subject road. The aforesaid instruction dated issued from the office of the engineer, chief engineer, however, indicates that the aforesaid payment is currently under process.
Of course, here the award is made. Now, in
We
this,
are covered under the same award, but that has not been yet paid.
you are under the same award.
Yes, my lord.
This 82 lakhs.
Yes.
Yes, my lord.
82
crores.
82 crores. Acha, you are under the same award.
Yes, my lord. On the
But
same
then it
stage
is
of
not
road.
paid.
Not paid.
Here also it is currently under process
Yes,
payment.
my lord. Yes, my lord. So, my lord, kindly come to para 8 of this order. Upon appointed query being asked, Mrs. So-and-so further submits that she has instruction that the aforesaid payment is likely to be completed within a period of 6 weeks from today. It appears that despite the judgment order of this court have been rendered way back on such and such, wherein after completion of verification of the petitioner's land within a period of 2 months, the entire exercise of acquiring the petitioner's land, if need be, and to make a payment thereof to the petitioners was directed to be completed within a period of 6 months from the date of submission of the verification report. Apparent that the payment as directed by this court has still not been released to the petitioners, despite they have been found to be settled, entitled, and the same having been awarded in their favor. However, before proceeding to hear the instant contempt petition, this court deems appropriate to post this matter after 6 weeks to enable the CGC Council to place the updated status as regards the subject payment of the petitioners. So, my lord, what I mean to say is that these two cases were on the same stretch of road covered by the same award. So, if time may,
You want the same order
matter,
like
yes,
this?
my lord, if the matter may be fixed on 2/9/2025.
Okay. By that time, she'll get the instruction as to the
Yes, my lord.
payment with regard to the petitioners.
The written instruction which my learned friend placed on this case is covering my case, this present case also.
The award also covers you.
Yes, my lord.
What do you say, Miss Mary?
Your Lordship, they are covered in the same award, same stretch of road.
And by approval is done in his
Approval
this
is
case?
done. Only payment is awaited at this stage.
Acha, the 5th October, the instruction that you have placed
Para
as 5th
7.
June, here government's approval, so approval is granted.
Yes, my lord. The written instruction received by the learned CGC is reproduced in para 7 of the order I refer to.
So, right then, the instant contempt petition is filed under Rule 9 of the Contempt of Courts Act, Contempt of Courts, within bracket Guwahati High Court Rules, 1977, read with Section 12. You can sit. Zaurangpur, your stand is also same?
Yes, my lord, we just received the letter from the state, my lord.
How about you have received
My lord, that
Yes.
award, yes, we just received from the state government.
this approval?
Yes, my lord.
So, same order will follow here also?
Yes, my lord, no problem.
Then under so and so, read with Section 12 of the Contempts of Court Act 1971 for non-compliance of the order dated 23/11/2020 passed by this court in writ petition C 184 of 2019. You all can sit, Miss Mary Zarangpui, and the order dated 23/11/2020 reflects that this court had directed respondent number 4 to see whether land passes of the petitioners are valid by giving an opportunity of hearing. And if on verification it is found that the lands have been destroyed, the authorities may take a decision to acquire acquired a land and if they decide to acquire the same, they shall initiate proceedings for acquisition of the land of the petitioners under the provision of right of fair compensation and transparency of land acquisition, comma, Rehabilitation and Resettlement Act 2013, full stop. It was further directed that the entire exercise for completing the process of acquisition and payment of compensation thereof shall be completed by the respondents within a period of 6 months from the date of sending of the verification report by the DC to the other respondents. Who was directed to verify, do the verification?
The verification team to be constituted is given under para 6, my lord, of the order.
Acha, acha. No, I mean, just in the initial thing, you make some changes. Initial. Okay. After I have said this is filed under so-and-so, by the said order. The said order dated so-and-so reflects, I have given in the first line. There you write. After that, reflects that a verification team was constituted. Make a marking there and write it in a separate page. A verification team was constituted of the comprising of the Deputy Commissioner cum District Collector, Siaha as Chairman, number 10, comma, the Senior Revenue Officer, Mara Autonomous District Council, comma, the Chief Engineer, Border Road Task Force, along with the petitioners, along with the representatives of the petitioners. No, along with the petitioners or their representatives. And the chairman of the said verification team, that is the Deputy Commissioner, was directed to carry on a spot verification of the land of the petitioners. And if it is found that, if it is found upon verification that construction of the road has been made upon the land of the petitioners, the Deputy Commissioner shall send the verification report to all the respondents. Full stop. It was further directed that before sending the verification report to the respondents, the respondent number 4 that is the Deputy Commissioner shall take a decision as to whether the petitioners had valid and genuine passes. And if the petitioners are found to have valid passes, the respondents would take a decision as to whether they want to vacate the same for the said for the said road construction. Full stop. It was further directed that if the respondents decide to acquire the land, then that will continue. They shall initiate proceedings for acquisition. I have already said. You can again write. They can initiate proceedings for acquisition of the land under the provision of that 2013 Act, which I had already dictated. The further direction made was that the entire exercise of completing the process of acquisition and the payment of the compensation shall be completed by the respondents within a period of 6 months from the date of sending the verification report. It was also observed that since 10 years have elapsed from the date, from the time of the road construction, since so and so, if it is found that the road construction had not taken place, and that only the debris or other materials were dumped on the on the land, resulting in damage of the land and crops, there will be no requirement for acquisition of the land. No requirement for acquisition of the land, and the petitioners may claim damages before the civil court as per law. The learned counsel for the petitioners, when the matter is taken up today, has placed an order dated 21/7/2025 by which this court before that, when the matter is taken up today, Miss Mary Kyangte, the additional advocate general, right?
Your Worship, government advocate.
Additional government
Government advocate.
of the state of Mizoram submits an order, a communication written to the district collector, Siaha district, Siaha, Mizoram, by which the Under Secretary to the Government of Mizoram had intimated that government's approval has been awarded. Government's approval has been given for the award number 6, 7 and 8 of 2021, amounting to rupees 56 crore 72 lakh 58,631 for acquisition of land in view of the road construction, that is Zaongling Mawhare MAWHRE Chapi CHAPI road. And she has stated that the petitioners are covered under the said award. Award number? Petitioner is covered by which award number?
My lord, that letter is not relevant to the present case.
There are so many awards number, 6, 7, 8.
My lord, this
All
is
the-
different case, this is for different case.
Your Lordship, I'm sorry, I placed a wrong record.
Acha, give me the,
It's award number 12 of 2024.
oh, this is award number 6, 7 and 8
Yes.
of 21.
Now this concerns award 12 of 2024.
Give me that approval then.
The approval date is 16 May 2025.
Acha, government's approval, where I've said, dated 16?
16th May 2025.
16 May 2025. Do you have the communication?
I have the communication in my phone only because
Is it in the
there are
affidavit?
as many
My lord,
as 14
although-
cases, so I...
Although I do not have the copy, my lord, it is reproduced in para 5 of the order which I gave you. Para 5,
Para 5 of the order.
which I gave you, my lord. Order dated 21/7/2025 in contempt case number 25 of
Acha, acha,
2019.
which is there? This is the one.
Para 5.
My apologies, Your Lordship.
Yes. 21/7/2025. This is a letter.
Para 6, my lord. Para 6, Your Lordship, may kindly see para 6.
This is not that order that she is saying, May. This is on August.
She is producing different letter, my lord. The one which we are concerned with is in reproducing para 6 of the order.
But this is not an approval order.
Para 6, kindly see para 6, my lord.
Huh. That
The
is by chief engineer.
kindly see para 6, my lord. I will read from the beginning, para 6.
I'm seeing this one. Okay.
Today, when the matter was called, Mrs. So-and-so appearing for the respondent submits that she has received instruction dated 21/7/2025, which indicates that the reassessment has been completed by the concerned department. And after the reassessment was completed, the Under-Secretary Government of Mizoram on 29/5/2025 approved the award number 12 of 2024. This is the one, my lord, we are concerned with.
Acha. Then again, you have to cut that part, that notification part, the order dated. Okay, that part you cut from Miss Mary part. Then you write. It is when the matter is taken up, Miss Zairam Sangpui, your letter I'm referring to. Okay? The one that was given to you on 21/7/2025. Okay? According to him, this letter covers him. Okay. Zairam Sangpui, Lanet CGC, Mizoram, submits before this court that she has received an instruction dated 21/7/2025 indicating that a reassessment has been completed by the concerned department, and after the reassessment was by the concerned department, and that the Under Secretary to the Government of Mizoram, Land Revenue and Settlement Department, on 29/5/2025 approved the award number 12 of 2024 to rupees 82,48,78,525.27 full stop. The said instruction dated 21/7/2025 issued from the office of the chief engineer indicates that the aforesaid payment is currently under process. Then you say about the Mr. So-and-so appearing for the petitioner submits places an order in a similarly situated case, being contempt case number 25 of 2019. Before that, you again write that this, just one line before that, that this award, that the petitioners are included under this award, right? That is award number 12 of 2024. (2024), right?
Yes, my lord, correct.
Or 5?
24.
24. Yes, and then you say that he had placed a similarly analogous case, being contempt case number so and so, by which this court had reflected the submissions made by Ms. Zairang Sangpui, learned CGSE Mizoram, by which it was so and so. What did I say? This court? Who stated that the aforesaid payment is likely to be completed within a period of 6 weeks from within a period of 6 weeks from
That day, 21/7.
the 21/7/2025, the date on which the said order was passed. It is noticed that although the award has been approved and as such the payment has to be disbursed on the petitioners, but the same has not been disbursed till date. As such, in accordance with the order that that the counsel appearing for the petitioner has placed, the CGSE, this court, no, not this court, the CGSE is directed to place the updated status as regards the payment to be made to the petitioners in view of the approval of the award. List this matter on 2/9/2025 along with not required,
Not
both the
required,
matters.
not required.
List this matter on 2/9/2025.
Deeply obliged.
This you can take it back, Miss Mary, this is not required. This order also you can give Mr. Michael to him.
Item numbers 4 to 9.
4 to 9, yes.
Well, here in this case, my lord,
There is a connected writ appeal.
yes, my lord, it is pending, my lord, matter is fixed for 21st of August for hearing, my lord.
The writ appeal is fixed.
Yes, my lord, this is appeal to 3/20/23 and
No, what happened on 14/7/25?
14/7.
14, because see
Yes,
the
yes.
last order.
Yes, yes, my lord.
Yes, list the last order, it is written,
Yes.
all the parties listed before the division bench today.
Yes,
So, what is submits, listed before today. So, what happened on 14/7?
this due to some the code on that day up to 3 it was sitting in principal bench. Due to positive time, this code it was not taken.
I couldn't get you, what?
Due to time, while it was not taken on that day. Again, as per our,
Due to paucity of time, it
Yes.
didn't reach.
yes, yes.
It was not taken on that day.
Yes, yes. So we prayed for fix again because there is urgency also on 21st of August.
Huh.
May I pray on 2nd of September, my lord, because 21st of August, this hearing is there.
Okay.
Three
So 28 and 34 violation. That is the issue.
We are in this case 28 and 38, mainly 34, my lord. Mainly 34.
So what do you say, Mr. Malhotra? That day it was not taken up, he said?
Let it come up as requested by my learned friend on 2nd.
Because same subject matter,
Same
if it
subject
is
matter.
pending there,
Yes.
then okay. Right. Mr. S.K. Medi,
I'm for railway, my lord.
for respondent number?
I'm for respondent 3, my lord.
3. For respondent number 3?
3, yes.
3 submits that the connected writ appeal could not be taken up on the last occasion when it was listed on 14/7/2025 due to paucity of time, and the matter is fixed on
21st August.
21st of August 2025. As such, he prays that the matter may be taken after 21st.
Yes, madam. 2nd of September, madam.
So he is praised that the matter may be taken up 2nd of September after the writ appeal is taken up by the Honorable Division Bench. Mr. Malhotra, appearing for the petitioners,
Item 4, 6 and 7, Your Worship.
appearing for petitioner number 4, 6 and 7.
No, Your Worship, in item 4, 6 and
Oh,
7.
acha, and item 4, 6 and 7. You are for all the petitioners?
Yes.
For the petitioners, you make it in item number 4, 6 and 7, huh? Same order.
Your Lordship, if I may, I'm there for the petitioner in item number 5.
5, you are for?
Item number 5, petitioners.
Item number 5, so and so for Mr. In place of Mr. Malhotra, you write his name, in item number 5. 4, 5, 6, 7. There are only 4 matters, right? Yes.
The 4 to 9.
My lord, and for the petitioners in item number 8.
Acha, petitioners, item number 8, huh?
My lord.
9 your?
Yes, my lord.
Acha. 9 you are appearing.
Yes, my lord.
My friend is appearing for the Union of India.
Acha. Zaurang Sampui for CGSC, for Union of India, and you?
For the state respondents, Your Lordship.
For state respondents, Ms. So-and-so. Appears. Okay. In the first item you write, Mr. Malhotra does not object to the said prayer, list the matter on 2nd of September. In item number 4, 6 and 7, huh? And 5 you write Mr. So-and-so and the same prayer, only the names will differ.
Yes. I'll leave.
Item numbers 10 to 13.
Lordship. Lordship, I'm from the petitioner, and my senior is currently out of station, so I'm.
Oh, again Mahindra?
Yes, Mahindra.
So tomorrow senior will be there?
Yes, he'll be here. So he's saying that these 3 matters may be taken up after 3 weeks. The Mahindra, the petitioner are engaging a senior counsel, so they're changing their counsel, it seems. So we're.
Oh, there will be a separate set of counsel for the petitioners?
Yes.
Acha, this is for quashing of the order.
Yes.
10/6/24, where bail is granted.
Bail. Yes.
And there was a stay initially, and the stay did not continue.
Yes.
There was a stay by this court.
My lords, that was only in one case here.
One case, right?
Only one case.
Acha, only one case.
Yes.
But then even in that case, stay did not continue later on.
No, my lords, that was stopped, my lords. Because of that judgment, my lords. Only when there are, my lords, specific circumstances.
Only then stay in bail matters. So what today he is praying for some time?
We have no objection.
And again the said bail application you have challenged for quashing, right? Oh, for onerous condition, onerous conditions.
Listed tomorrow.
Yeah. And there is no stay there.
No stay.
Because if it is stayed, then again we cannot enter into the onerous conditions.
Yes. No stay. No stays.
Okay. Acha. Mr. So-and-so? So, Mr. Malhotra?
Your Worship, it can come up in the first week of September then.
Huh. Okay. So, any day on first week? Fix a date so that your senior can come.
Worship, maybe second, third week. After 3 weeks, it's maybe 28 August.
8th of August. 8th of? No. You do it on what? 2nd of September?
2nd September.
Yes, second September.
Okay.
2nd September. Okay.
Too many cases, right? So do it on 4th of September then.
4th September.
Mr. So-and-so, appearing for the petitioners, submits that the conducting counsel has some personal difficulty today in conducting the matter, in doing the matter, and as such he has prayed for some accommodation. Ms. Linda appears for the state, and Mr. Malhotra, you are appearing for?
Your Worship, I am appearing in item number,
11 and 13.
11 and 12.
Oh, 11 and 12.
Yes.
As far as 10, who is appearing?
Your Lordships, I am appearing in 10 and 13. For respondent 2.
In item number 10?
And 13.
10 and 13 you are there?
Yes, ma'am.
I am in 11 and 12.
So only Zakir Hussain is the respondent, right? Or
No, it's
who?
in 10. Mr. Zakir Hussain.
10, yes.
13 is-
Mr. Jordan Roaming Tonga appears for respondent number 2. As prayed for by the councils, let's the matter on 4th of September.
Obligation.
In item number 11, who is appearing?
I'm then in 11 and 12.
11 and 12.
11.
Yes.
Respondent number 2.
Respondent number 2. Like in place of Jordan, you write Mr. A.R. Malhotra. Same things will ensue. And item number
13.
13,
I am appearing.
you are appearing. So 13, write Jordan. So fix it on 4th of September.
Item 14.
I think here service on the victim, service of notice on the victim is awaited. You have instruction?
I have
Or it is served?
served on 25/7/2025.
25/7. So you are there for the. You have challenged the conviction order, right?
Sentencing, my lord. There are 4 sentence order. 3 are directed to run concurrently, and the last one to be consecutive after the other. That has been under challenge.
Okay. 3 concurrent.
3 concurrent, and the 4th one consecutive after those 3.
And 4 different cases.
4 different cases, but it appears that the time of the offense are all the same and related. Nature of offense.
Okay. So what will you do? Today you will do, or you will do some other day? Otherwise services complete. Oh no, there is no representation. So let me appoint an amicus curiae today.
Yes, Your Lordship, plus we do not have enough materials with us.
Okay.
It will be proper if the case records are called.
Case report was called.
Records are not called.
My lord.
Uh-huh. Records are here. The records are here.
Yes.
If you want extra copies, we will give it to you.
Yes, if record.
That will be
extra
required.
copy,
That will be required, copies of the LCR.
yes.
No, that are there
Yes, ma'am.
for my as well as your perusal. And what records, what papers you want? What papers you want? The
Your Lordship, this is the appeal from jail, so we don't have any documents. So we need the entire documents.
oh, this
Whatever
is
we
an
can
appeal,
get.
so better a paper book is prepared and served upon all the parties, because otherwise they'll not have any papers.
Yes.
Even the appellant will not have.
Enough materials.
So let a paper book be prepared.
Yes.
Okay. Now, so, right. Heard Mr. So-and-so and Mary Kyangte for the state of Mizoram. It is Miss Mary Kyangte has placed a communication dated 25/7/2025 by which it is reflected that the service upon the victim is complete. Is complete, full stop. It is also stated at the bar that this instant application is taken on is taken up as a on the request made by the accused appellant from jail, and as such it is desirable that a paper book is prepared by making all the paper book is prepared by annexing all the relevant documents therein. Prayer is allowed. The registry is directed to prepare a paper book and serve the same upon all the parties. List this matter after 3 weeks, after preparation, or after 3 weeks, on a date to be fixed by the registry. After 3 weeks. They'll take time. It's okay. There are 4 matters, right?
There are 4 cases.
And then 4 matters are separately heard, a judgment separately given, one after the other.
Yes, my lord.
As it is required.
Separately.
Yeah. So there has to be 4 paper books only. And so, paper books, 4 in numbers, separately in respect of all the cases. 4 in numbers, separately in respect of all the cases. Because one case cannot have an effect on the other. And within a reasonable period of time, the registry may prepare the paper book within a reasonable period of time and serve the same upon the upon all the parties. Because I'm told that there are so many cases where the registry is proceeding with preparation.
Yes, my lord.
So this will take little time. Okay. There is anything more?
Your Lordship, the legal aid counsel for the informant.
Yes. Since the service upon the victim is complete and there is no representation.
Informant instead of victim.
Okay. Informant is the mother, father. Who?
He is the teacher of the school.
Teacher of the school. The
yes,
service is
teacher,
upon,
yes.
Otherwise teacher of the school will not be support person. Either victim or guardian or the support person. So?
Because in terms of the order dated 21/7/2025, notice was served upon the informant.
Informant. He is the headmaster of Home Mission School, Jembao.
Yes, my lord.
She is studying there.
Yes.
He lodged the Ejahar. It's okay, he can be arrayed as a support person.
Yes, my lord.
Right. Okay. Now, since the service is complete upon the informant, and on 25/7/2025, right?
25/7/2025.
2025, and there has been no representation from the side of the informant. The escort appoints who? Any legal aid counsel? You can appear, Joseph. Yes, Miss. You are not a legal aid. Acha. Let me give a legal aid counsel then. Mr. Who are regular in these in this list? Yes. Yes, come forward. Who is there? Lokrukungu Pautu. Yes. Okay. Mr. Lokrukunga Pautu is appointed as a legal aid counsel to defend the informant, who is the support person of the victim. List this matter after 4 weeks. Then we will see if it is not prepared, we can give some more time, because if they are preoccupied with others, after 4 weeks. Okay?
Item 15.
My lord, in this case, we are ready to take up the matter for disposal, my lord. So let this matter be taken up after part 1, my lord. Let them finish off the part.
Okay.
My lord, I have some submission. My lord, here, my lord, if it is, my lord, admitted, then lawyer court record is required, my lord. Second thing is, my lord, every affidavit is filed, my lord, in contempt, criminal petition, as well rejoinder and the additional affidavit. It was not as per law. So
My lord can see.
that aspect, your lordship first produce, because there is we filed
No, as far affidavits not filed in accordance with law, we can take care.
Yes, ma'am.
But what you are saying, you need records.
Yes, my lord. This
What record? This is quashing of the complaint.
Yes,
And
yes,
complaint, we will see prima facie whether it makes out a case.
It is not annexed in the complaint petition properly, ma'am.
No, the what annex, complaint petition is there.
Yes, ma'am, but annexer is not complete, ma'am.
No, my lord, we have annexed all of the documents, my lord.
So I have got the original,
This is that medicine which is found to
my
be
lord, drugs and
bad.
cosmetics. My lord, there are only two submissions that we are going to make in this case, my lord, and I don't think we'll have to examine the records. First is, my lord, when the process was issued, my lord, the first question is whether the court exercised gave a reason, my lord. That is
So cognizance taken.
cognizance was taken, and we are saying that the cognizance was taken, and then the court did not give reasons when process was issued. That's the first, my lord, and your lordship will examine if we are right or wrong in that one. And the second, my lord, is the appellants, my lord, they were arrayed as directors of the company. And now our humble submission, my lord, is that as per the Supreme Court judgment, we are not supposed to be impleaded in this case. That
Only
is
who
always-
takes care of the day-to-day
Yes,
activities.
correct. So we'll see these two. These are the two submissions we are making, my lord.
My lord, if hearing is, my lord, then the another date may fix, my lord. But this the point, my lord, is regarding the affidavit, whether the petition is maintainable, my lord.
The reason, my lord,
because that first, your lordship, my lord.
The reason I'm pushing this, my lord, is because on the last occasion.
How this affidavit is filed, I want to show. This so first, your lordship may turn the reply.
Wait, which reply?
Rejoinder affidavit filed by my friend.
There is an additional affidavit to bring on record certain documents.
Yes, ma'am. And thereafter this.
Rejoinder affidavit, yes.
Yes, ma'am. This is page 13.
Page 13.
13.
Acha.
This I have been authorized by the other petitioner to file the present petition. That is criminal petition number 3 of 2025, including all connected applications, and affidavit criminal petition 3 of 2025. However, since I am presently out of station and not in position to physically sign the present rejoinder affidavit in reply to written application filed by respondent, I have authorized so and so, no address to sign, swear to file the present rejoinder affidavit on my behalf.
This is an authority. And anyway, in a criminal petition, what is the requirement of all these affidavits?
Yes,
I will see the complaint.
But this man, he who filed affidavit, whether he can stated they own word that all the statements filed by in contempt criminal petition are true.
No, we are not required to go into all this criminal complaint. This is not a writ proceeding.
Yes,
this is not an
yes,
appeal.
Another thing is that this main petition criminal petition filed, he was not authorized by the other person. There is no authority when affidavit is filed. Affidavit page 34.
Sanjeev Kumar Bhatia.
Yes, ma'am. And it was
They have filed their affidavit, Wakalat Namas, madam.
Wakalat is there, but
And that being one of the applicant has been acquainted with all, I am competent to swear on behalf of the applicant's accused person. So
yes, how he should be authorized, madam. Authorized to file. And mainly company is not before this honorable court.
My lord, as per the Guwahati High Court rules, my lord, any person who knows the facts can sign.
How is it criminal case? In writ proceeding, this maybe it is there. How in criminal proceeding the unknown person can swear this affidavit? In so far,
no, this is not unknown. Sanjeev Bhatia has filed it.
And thereafter this the reply was filed by the unknown person. He has no address. This authorization letter. I have authorized so-and-so, he has no address to.
Now that I am saying, I will not go into all these affidavits. I'll see only the complaint. If it makes out a case, okay. Otherwise not.
Then this, may I pray this another date may be fixed for final disposal.
My lord, the reason why I'm pushing this, my lord, is because on the last occasion, virtually he appeared and he
Yes,
said,
yes,
Lordship,
yes.
he wanted to appear today personally, physically, and therefore this case was fixed for today.
It is there, but these 2 points, I'll give reply, my lord, because today this point also I raised this, whether, and then if Lordship is, because
You are not prepared today.
because yesterday the criminal petition is, contempt complaint petition is before the magistrate, my lord, learned magistrate. I submitted that I have not pursued this said complaint petition because the case is pending before the High Court. So there is nothing is there. They have already appeared. Yesterday they were not there. So another day nothing, no warrant, nothing, non-available warrant equally against them. Nothing is there. Not to worry.
No, he wants time, he is forcing. Let him do it on some other day then. Otherwise, cognizance is taken and they are proceeding.
They're proceeding, my lord.
Proceeding,
This
my
is
lord,
the problem.
yesterday I was there, my lord, before this learned magistrate.
But the fact remains, see, medicines were tested and it was found not of the standard quality.
Correct, correct.
Otherwise, prima facie, the case is made out against you.
There is one issue with that also, my lord. The test, as per Rule 45, my lord, the test was supposed to be done within a particular period, and this was also not done within a particular period, my lord.
Oh, that can have some effect in contaminating the.
Correct.
No,
And
no, no.
these
It is not there.
these
We have
factual,
explained that.
my lord, these factual issues, lordship, these factual issues with respect to whether this testing was done correctly or all of these things, my lord, this will be disputed, my lord. If we do not make out a case here, this will be disputed during the trial, my lord. But in this case, my lord, the only thing that we are concerned with is firstly, the most important one, my lord, is whether these directors, whether they should be made accused persons. This is the
As far as I know, of course, I have gone through all cases where it is said only the person who is responsible for day-to-day activities
Yes, they
will be the responsible
Yes,
person and
yes,
he should be made.
they-
Otherwise, other directors are not required.
correct.
Yes, there is some tester, there is some the managing director. Those are responsible. It is already explained in the company.
And you have in your complaint stated that one of the respondent is mainly responsible for the manufacture and one for testing.
Testing, yes. Testing
But
is,
the requirement is in a complaint petition, whoever is responsible for the day-to-day activities.
that question may be raised before this trial, at the time of trial also, because they are now in bail.
And that is also done, but
So-
whether the complaint
so-
is maintainable,
Yes, I'll try to satisfy. On
Not
next
today.
week. Not today.
and what is the other ground that you have taken to challenge this
So
complaint?
the other ground, my lord, there is one judgment.
Cognizance.
Of cognizance. So there's one judgment only we are relying on, my lord. And this judgment deals with these two issues. So we are relying on only one judgment, my lord. If we were going to have this hearing, my lord, I would be producing only one judgment to your lordship. That's it, my lord. Simple case.
But
And
he
if your
wants-
lordship is not satisfied, we'll go back to the lower court.
He wants time today.
Yes.
So Mehdi, decide whether you are going to do it today.
Well, they another date, because I have to go to.
Otherwise, it's not a very long matter, it's a
Yes,
small
yes,
complaint that I have to see.
Yes.
And the charges are, the cognizance is undertaken under what offense?
It is here, my lord.
Section 16, 18 of the Drugs and Cosmetics Act, my lord.
16 and 18.
16 and 18, my lord. So the punishment is maximum one beyond, not more than 2 years, my lord, basically.
So we will see whether 16 and 18 is made out. Mr. Mehdi, you can do it today.
Well, another date, my lord, because morning I thought that my lord is.
Last night only my learned friend had said we will do it today, my lord.
Another date, my lord.
So, what is the difficulty then?
Because it may take time also, my lord. So the another date, my lord, any date, my lord.
So 16 is standard of quality.
Correct, my lord.
And 18 is prohibition of manufacturing. Okay. What is there in 18?
It is prohibition of manufacture and sale of certain drugs and cosmetic. any drugs which is not of a standard quality and misbranded, adulterated, and any cosmetics. These are
18C, my lord, if I'm not mistaken.
Manufacture for sale drugs and in equivalent license issued for. Okay, there is a question of license here.
I'm not, but I could be wrong, my lord. I have to check the record, my lord.
It's okay now that he is not willing.
Yes,
it's okay. So, right here, Mr. S.K. Medhi, appearing for the respondent complainant, submits that he is not prepared with the case today and he has prayed that some time may be given. The prayer is allowed. Oh, Mr. Joseph, however, objects to the said prayer. Mr. Medhi has submitted that he couldn't prepare the matter because of his preoccupation with some other matter, and he has prayed. Oh, that I have already said, right? Oh, you can say, and then the prayer is allowed. List this matter after 2 weeks.
20th August.
Next date you should not take time. You'll do the
Yes,
matter.
sir, 28 minutes.
List the matter on 28th of August 2025.
28.
28.
Yes.
28, huh?
Item 16.
May I please your lordship?
Yes.
Lordship, in this matter, lordship, I am appearing for the respondent number 6 and 7 for Income Tax Department, lordship. Lordship, recently department instructed to appear in this matter, lordship. So we need some time to respond because
So
the
you
instructions are needed.
So you are for respondent number 7 then?
6 and 7.
Huh, okay. 6 already, 7 you are appearing, okay. And you are there for the petitioner?
Yes, yes, Your Lordship.
So you need some time?
Lordship.
This is for what? Quashing?
No, this is regarding seizure of cash.
Or seizure of cash?
Yes.
Jimma?
No, Your Lordship.
Returning?
Yes, of course. Cash was seized by Assam Rifles, and it was handed over to the police, and without court order or any instruction. So the police handed over it to respondent 6 and 7.
Why to the tax officials? They handed
Yes.
it over?
They are income tax officers, yes.
Money was seized by the army, by the Assam Rifles.
Assam Rifles, yes, they handed over to Mizoram police.
Why is that seizure done?
Yes, it was seized from 3 foreign nationals.
Oh, 3 foreign nationals?
Yes, it was belonging to the petitioner.
Okay, we will see in the next date. Yes. Right.
Lordship, kindly matter may be fixed on 8th of September, lordship. Where another income tax matters are fixed in Isle bench, lordship.
Okay, fine. It is reflected in the office note dated 1/8/2025 that service upon respondent number 6 is complete, and it was also reflected on 0/4/8/2025 that a service upon respondent number 7 is not complete. However, when the matter is taken up today, Mr. I forgot your name, Mr.
JP Moore, lordship.
JP Moore. JP
Yes.
Moore appears on behalf of respondent number 7, and you will file wakalat nama?
6, lordship, 6 and 7.
He will be appearing both for respondent number 6 and 7 and would file the wakalat nama. You have filed or you will?
Lordship, we are not required to file the wakalatnama because we are the senior standing counsel of Income Tax Department, lordship.
Okay. Would be appearing for respondent number 6 and 7. Mr. JP Moore has also prayed that some time may be given to them to prepare the matter. The prayer is allowed. List this matter on 8th of September 2025 as prayed for. It's okay for you, the date?
Yes.
Yes. Linda, it's okay?
All right.
8th of September 2025 as prayed for by the councils.
Obliged, Lordship.
Obliged.
Highly obliged.
Item 17.
What happened, my lord, the respondent 11, my lord, the notice is received, but he already transferred. I am instructed, my lord, this new one is given, and there is Okalat number, but he is not party respondent.
So 11 has been transferred.
Transferred.
Now in his place there is someone else.
Yes, my lord.
Again impleading.
I will have to implead, my lord.
Yes, my lord. That yesterday matter, the same man is now there.
And fortunately, Mr. Mehdi will be representing the new incumbent. So,
Right?
yes.
Mr.
Lot of
what?
phone
Mr. S.K. Mehdi appearing for?
Actually, 11, my lord, he received. Respondent 11 received a notice, my lord, office received, but he already transferred. So I am instructed to appear now because new one is sent Okalat now. That is, he is not party respondent.
S.K. Mehdi submits that respondent number 11 has been transferred and in his place the new incumbent has joined, and as such a new incumbent has joined, full stop. Mr. So-and-so appearing for the, you are Pautu.
Yes, ma'am.
Mr. Pautu appearing for the petitioners as such submits that he may be allowed to file an impleading application for impleading the new incumbent who has joined in place of respondent number 11. Prayer is allowed. List this matter. You can file one, list this matter after 2 weeks.
Copy of petition maybe.
I will start a copy. I will start in
next time I will appear because and the contempt petition also.
It is also directed that Mr. Pautu may serve a copy of the petition to the learned counsel appearing for respondent number 11. No, to Mr. S.K. Mehdi.
Yes.
During the course of the day.
Yes. I'm
obliged.
Item 18.
This is also contempt. So many contempt petitions here. The orders are not followed. This is what? This is counting service.
Counting of past service for placement to senior citizen grade.
So, any instruction, Miss Mary?
Your Lordship, I have already filed my show cause reply affidavit.
I haven't received.
It is not in the records.
Your Lordship, it's ready for filing. Sorry, it's ready for filing. I'll be filing in the course of the day.
You are for?
Respondent number 1 to 5, Your Lordship.
She represented all the respondents.
1 to 5. Acha, all the respondents. Okay, right. Whether it was written.
Your Lordship, if I may be given another 2 weeks' time for filing.
It's already ready, you said?
Yes, I thought that it's ready because I have the extra copy, but then I am seeing the correspondence which is sent to the under secretary to obtain the signature of all the respondents, etc., which we have sent on 15 July 2025.
This is a petition. This is a petition under Rule 9 of the Contempt of Court Act, Contempt of Court, Guwahati High Court Rules 1977, read with Section 12 of the Contempt of Court Act 1971 for non-compliance of the order dated 4/7/2024, passed in writ petition number 66 of 2024. Full stop. By the said order, it was directed that the authorities may count the service rendered by the petitioners under SSA within brackets CSS as qualifying service for their placement to a higher grade, right?
Yes,
To
madam.
a senior grade.
Senior selection grade.
And there was an order for some speaking order also. What is that? Higher grade, right? Then you say, and it was also directed that the respondent authorities will be at liberty to verify and scrutinize the service particulars of the petitioners, and that the entire exercise should be completed within an outer limit of 3 months from the date of receipt of the order. However, the said directions were not complied with and the instant contempt petition is filed. Miss Mary L. Kyangte appears today and submits that she will be appearing for all the 5 respondents and that she will file her counter to the said application. Prayer is allowed. List this matter after 2 weeks, and in the meantime, and the respective counter will be filed and a copy will be served upon the counsel appearing for the petitioner.
Will you oblige, Your Worship?
We will oblige.
Item 19.
My Lord, I file my power for respondent number 1 and 4. Then I may be given 3 weeks time for filing my surplus reply.
1
and 4.
And what about 2 and 3 not complete? You had already taken time to file affidavit on the last occasion. And 2 and 3 is not complete. Unserved notice not yet returned back, so and so. Okay. So, AD card not unserved notice. So it was, of course, it went on 4/8/2025, very recently. We can await for some more time.
We can await, madam.
As far as 2 and 3 are concerned.
Yes, Your Worship.
It's heard, Mr. You are any Lalen Kauli?
No, my lord. Lal Fakoma. The name.
Fakauma, yes. Fakaufa, right? So and so for the petitioners. And Mary Lal Fakauma. And Mary, you are appearing for which respondent?
Respondent number 7.
Miss Mary appears for respondent number 7. Is received by the, okay. Full stop. Ms. Zaurang Sangpui, learned CGSE, prays before this court that she may be allowed some more time to file her counter in the instant contempt petition. The prayer is allowed. It is also reflected in the office note that service upon respondent number 2 and 3 is not complete. Since these steps have been taken only recently, this court deems it fit to await for some more time with regard to service upon with regard to service of notice upon respondent number 2 and 3. List this matter after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
For orders, item 20.
There is an I here.
Yes, Your Lordship. My lord, this is an application for condonation of delay of 535 days in filing the connected appeal.
Condonation of delay?
Yes, Your Lordship.
No, this is additional affidavit. Oh, this is additional documents to be brought on records. Interlocutory application 59. Oh, otherwise 59 is for bringing into record.
Yes, 50.
49 is delayed. 49 is delayed.
Delay is IA 49.
Of IA 49. Okay. So, there is already a written objection.
Yes, Your Lordship. It's ready for hearing the matter on the IA.
How many days delay?
535,
535.
my Lord.
Long delay?
Yes, Your Lordship. The reason being is that, Your Lordship, what we will try to impress upon this Honorable Court is that the delay was unintentional but due to lack of knowledge.
Acha.
Now, Your Lordship, just coming to the brief facts of the case, just to better understand the situation, although I've also mentioned it at page 4.
Page 4 of the IA?
Yes, Your Lordship. We are the children of one gentleman called Mr. K.T. Kuma.
Wait. Page number 4.
Page number 4. My explanation for the delay starts from para 2, and I'm referring to para 2 sub para 1. Now the present applicant, as well as the respondent.
No, where is para 2? Ouch.
Page 4. Page 4 of the IE.
What happened? Wait. Just got stuck in the wheel. Just see what has happened. Ouch. Just pull that chair. It got stuck in the wheel. My God. Will it come out? My God. Thank you. It got stuck in the wheel, my gown. It's too long.
Lordship is okay.
It's of my senior, Mr. D.K. Mishra, so I always wear this. And he's a tall person, so it has become very long for me. Okay, so paragraph 2?
Paragraph 2 is at page 4 of my IA.
Then?
So this is my explanation, and I'm referring to para 2 sub para 1, the Roman number 1. As the name is reflected, Your Lordship, our father, Mr. K.T. Kuma.
No, this is not our father, that the suit property. You are referring to 2.
Yes, originally
and
registered.
Roman 1.
Yes, Your Lordship. The suit property in question,
yes.
covered by LSC. LSC is Land Settlement Certificate, which gives us the title with inheritable rights. Number so and so.
Land Settlement Certificate.
Yes, Your Lordship. So it was originally registered in the name of K.T. Kuma, who is the father of the parties. And he passed away on 14/4/1998. After his demise, Your Lordship, we approached the Lok Adalat. All the siblings approached the Lok Adalat, and we entered into a settlement to distribute the properties. Accordingly, this Lok Adalat award can be found at Annexure 1, page 13, 1-3.
Okay. Yes.
So the respondent's name at page 13, Annexure 1, the respondent's name right below the LSC 17 of 69. The first name is the name of the respondent, whereas the last name is the name of the applicant. So our
Arzoya.
Arzo Moya is the applicant, and Zosang Zuala is the respondent. So our respective share to the property left behind by our father was recorded as per the terms of this settlement passed by the Lok Adalat. So from that date on, since passing of the Lok Adalat award in 2000, we have been all enjoying our properties peacefully. No disturbance, nothing. Now, after my demise,
after your demise?
Yes, Your Lordship. Now, the present case, both the applicant as well as the respondent have passed away. Now they are being represented by their respective legal heir, that is their respective wives. Now, Your Lordship, the present applicant, I passed away on 30/12/2017. 30/12/2017, I passed away. After my demise, Your Lordship, in 2023, in the year 2023, an airship certificate was applied by the present respondent behind my back without informing anyone, and in respect of that suit property, which has been distributed by the Lok Adalat. Notice was never issued in the airship certificate case. It was issued on the same date itself, in utter violations of the principles of natural justice.
So in that heirship certificate case, what happened?
Heirship certificate was allowed and issued to the respondent.
The entire property?
The entire property. Now, in the heirship certificate case, when they filed their application, they suppressed material fact. They did not inform the court about the existence of the Lok Adalat award. They merely filed the application stating that I am the last surviving son of Mr. K.T. Khuma. As such, I am entitled as per our inheritance law.
Now, who filed this heirship certificate?
The present respondent.
Present respondent?
Yes, the respondent. During his lifetime, after my demise, I passed away in 2000.
During his lifetime, after your demise. He died when?
He died on...
You must be knowing.
30/12/2017.
No, that is the date of my demise.
30/12 his petitioner died.
He passed away on 15/11/2024.
2024. Okay.
Yes, he
in
passed
23, he filed the heirship certificate.
Yes, he filed the heirship certificate. Now, I would like to take your lordship's attention to page 22, annexure E. Sorry, annexure 5.
But what you are submitting is on merits.
No,
now,
I'll
first
come
of
to
all,
that.
say what,
So,
what is
I'm
the reason?
What I'm trying to impress upon your lordship is that why I have come so belatedly is because I never knew about the existence of this heirship certificate. And I did not know that the property has already been mutated into the name of the respondent. I came to know about it only in 2025.
So property mutated in 2023 itself?
That also I did not know. So what I'm trying to impress upon your lordship is that at page 22 of my IA, as can be seen, your lordship, the order allowing the heirship certificate is dated 5/7/23. At the next page is the heirship certificate.
Issue heirship certificate in respect of LSC or to the petitioner.
Yes.
So he is
Josang
Juala.
Correct. So this is dated 5/7/23.
And the next is heirship certificate.
Next, at the heirship certificate at the bottom, your lordship, the date is written 5/7/23, meaning that it was issued on the same date itself without issuing any notice.
No, dated is 5th July.
5th July.
23. Yes. Okay.
So 5/7. So on the same date of the application, the heirship certificate was allowed without issuing any notice. The normal practice out here, your lordship, is that when we file an heirship certificate, the court would normally issue notice by way of newspaper publication. One which is widely circulated, and one in the area where the property is located.
So those publication not done.
It was not done in utter
because
violation.
he said he is the only heir.
Correct. And also he suppressed the material fact about the Lok Adalat award. That was not informed to the court. So, in any event, your lordship, after he passed away on 15/11/2024, the present legal representative of the respondent, that is the wife of the respondent, she called for a family meeting sometime in the month of...
wife of Josang Juala.
Yes, wife of Josang Juala called a family meeting in January of this year. I believe it was either January or February of this year, in 2025. Therein, she produced a will allegedly executed by this Josang Juala, bequeathing all the property to his wife and his children.
Achha.
The property which was already divided by the Lok Adalat, he had bequeathed it the same on the strength of that heirship certificate, saying
to
that
her and okay.
To her, basically to his family members only. So thereafter, your lordship, and as I was in utter shock, I left the family meeting disappointed, and since a copy of the will was not given to me, so I am not exactly in a position to say what exactly is the content of that will. But the bottom line is that I was informed that Josang Juala has executed a will bequeathing all the property to his wife and children, leaving me out totally in violation of the Lok Adalat award. So that's how I came to learn of the existence of the heirship certificate. Based on on the family meeting in the month of February of 2025, I met my present counsel and asked him to make an inquiry about whether any heirship certificate has been issued in respect of that property. In fact, Your Lordship, I had even sent a letter to the Revenue Department, which is at page 16. Page 16, Annexure 2.
Exactly. 1 second. Wait. 16.
16. This is dated February 4th, 2025. Basically requesting them that, look, this property has already been divided between the siblings. If any application for mutation is applied, please do not entertain it without informing me. And I even gave them a copy of the Lok Adalat.
So 4/2/25, you have made this representation to the secretary. Okay.
Correct. Revenue Department, Land Revenue Department. Now, we have this system in Mizoram where we pay our property tax through online. So if you are aware of the LSC number, then the registered owner will be mentioned. So accordingly, I did an online search in the website of the Land Revenue Department at page 19.
During all these years, you had not given your whatever you said, your tax. You have.
No, I've been paying tax. I've been paying tax. This online
but then
system.
the property was not in your name. How were you paying tax?
No. Before, Your Lordship, this online payment scheme is very recent.
Achha.
It's only been about 2 years or so, 2-3 years. Before that, we used to go to physically pay, and they'll just give you a receipt. So it was we would not know who is the registered owner. In any event, Your Lordship, after all this event that took place after the family meeting in January of 2025, I did an online search at page 19. The name of Zosang Zoala is seen as the registered owner against the sued property.
That is what I am saying. That was done in the year 2023. What? 20?
They
when
mutated
was
in
heirship
23.
allowed? 23.
23.
So from 23, you did not know that the land is no longer in
Physical
your name.
payment, Your Lordship.
Physical payment also you will know on what land you are.
No. What happened is that out here, the practice is that they normally use the previous receipt where all the LSC number is written.
So that
They don't do
continues.
a physical check, my lord. We don't do physical check.
So 19, page number 19, you came to know, right?
Yes. So all these things, I became aware about the existence of the heirship and the mutation only in the year 2025.
So this is land settlement certificate 17 of 1969.
Correct.
Is in respect of this land, the entire land which your father had. That.
Which had been divided by the local
Which has
Adalat.
been divided, yes.
So now he has become the owner by virtue of that heirship for the entire land now, in violation of the Lok Adalat award.
Show me that heirship certificate again once.
Yes, at the last page, Your Lordship.
No, Lok Adalat.
Lok Adalat is at page 13.
13.
Yes.
So this is LSC 17 of 69, right?
The same, one and the same.
Achha. 17 of
There's a big building over the land.
69, then area covered by so-and-so till the Iman Baptist Church, now rented so-and-so, area now occupied by him. Shop area now rented by so-and-so, residential area now occupied by her. Okay. Remaining area not mentioned above shall belong to Zamawiya.
Yes.
Okay.
So it's a different, it's a big building with different floors. So whatever is not mentioned, the remaining portion.
Same building with different floors.
Yes.
So one floor each.
One
was
floor
given.
this person, another floor that person. So that's how. But it's covered by one LSC. That is the problem. So
LSC 17 of 69.
yes. So during what I would like to submit here is that, Your Worship, prior to my death in the year 2017, the present respondent has never challenged the Lok Adalat award. No case has been filed against me. Not a single, let's say, eviction notice that I did not receive anything as such. Even after they obtained the heirship certificate in 2023, they have not filed any case against me. As such, it was not possible for me to come to have knowledge about the existence of the heirship certificate.
Okay, you have gathered your knowledge in 2005, 25.
25 only.
January, February.
Yes. So, and coming back to their objection, Your Lordship, which is rather vague and rather unsubstantiated.
And then you contacted your advocate and then you filed the application when?
This present application, I filed it in the month of, on 21/3/2025, within 1.5 months. Because it took time to obtain all those CTC and we had to do a blind search, Your Lordship. In any event, Your Lordship, I would like to take Your Lordship attention to the objection filed by my learned friends. Here at para 4, the relevant page is at page 4. Out here, Your Lordship, they have, I think their submissions are contradicting to the facts. I would like to take Your Lordship's attention to the last paragraph at the last,
No, page number 4 has single paragraph. It's a continuation of paragraph 4.
yes, the last
It is only after a demise.
no, Your Lordship, the line number 8 counted from the bottom. The
The
respondent,
further states.
May I
Okay.
read, Your Lordship?
The respondent further states at the time of applying
Applying for the
heirship.
heirship certificate in 2023 by her husband, Sri Zosangswala. All the siblings knew about his action for such application and they all consented to it by raising no objection.
Acha.
How could I have raised my objection? Because I was already, I had died in 2017. This is an unsubstantiated submission. It's contradicting the facts. How could I have raised
In the
the
order
objection?
also, in the order also nothing is written, yes.
Correct, Your Lordship. So this is an unsubstantiated submission. Now, my contention that I had knowledge about the heirship certificate only in January of this year is also supported by their submission at para 6 at the next page. May I read, Your Lordship? With regard to the contents of para number so-and-so of the application, the respondent submits that at the time of opening the will, as stated by Sri Zosangswala on 30/1/2025, at the residence of the respondent, it was clearly announced that all the present family members, including the present applicant, Smith so-and-so, that Sri Zosangswala had obtained heirship certificate so-and-so in respect of the LSC number 17 of
This
19.
is 25 years, January.
So what I'm trying to say is that, what I'm trying to impress upon Your Lordship is that even they admit to the fact that I was informed about the heirship certificate only on 30/1/2025.
It's okay, Mr. Counsel for the respondent. Let us hear the matter on merits and a delay be condoned.
Delay, we can condone and then on merits we can issue notice.
Then after that, let the delay be condoned and the matter may be heard, and then of course the first appeal is already numbered.
Numbered.
Okay. So write in the IA application. This is an application. You have something more to say?
I have some citations, but
My Lord, my
Not
objection may also
required.
be.
Let the delay be condoned, and then.
Very well,
My Lord, my objection may also be reflected in that.
Hey, your objection, I'll write it down.
A normal, general objection.
Yes, write in the IA, this is an application filed under Section 5 of the Limitation Act, 1963, for condonation of the delay of 535 days in preferring the regular first appeal against the order dated 5/7/2023. And what is it? 5/7/23? Oh, that is the one you had shown.
Yes.
5/7/2023. That is not the order. You have shown the certificate.
No,
Order,
the
yes,
order
yes.
also at
Order dated 5/7/2023, as well as the heirship certificate.
No.
Number 911 of 2023. Dated 5/7/2023. Passed by the Court of Senior Civil Judge 3. Civil Judge 3. District Court, Aizawl. The applicant states that the land that their father owned in view of the LSC certificate or LSC land settlement certificate number and land settlement certificate number 69 or something, right?
17 of 1969.
17 of 1969. No, what did I say? The applicant states? No, not that. The land, a land was owned by their father, White, LSC, number so and so. Where is the Lok Adalat? Yes. On 18/10/2000, a Lok Adalat meeting was held and wherein both the parties were present, that is the petitioner and the respondent, and parties had come to an amicable settlement at the Lok Adalat that the said land under LSC 17 of 69, just in the top of the line you say, after the demise of the father of the applicant, right?
Applicant.
Respondent also?
Parties.
Parties. Father of the parties. Okay. Go to Lok Adalat then. And what did I say last? Was divided amongst the brothers, amongst the sons.
Sisters also.
A son and daughters. And in 4 parts, not and. Son and daughters in 4 parts. Giving respective share to all the brother and sisters as mentioned in the Lok Adalat, not mentioned, giving respective share to the said brother and daughter, said son and daughters. Full stop. The terms of settlement was reached in the said Lok Adalat sitting held on 18/10/2000. It is the case of the petitioner that thereafter the respective parties were enjoying their respective share since then. However, it is known to the applicant much after that on 5/7/2023 the respondent had filed an heirship certificate application being numbered as 911 of 2023. Under section 30, subsection 3 of Mizo Marriage, Divorce and Inheritance of Property Act 2014, in respect of the aforesaid LSC number ISOL AZL-17 of 1969, which was in the name of their father who had passed away on 14/4/1998. Mr. Pautu, appearing for the...
Lalfakoma.
Oh, Al Fakama. I got confused, sorry, don't mind. But what I said just now? Fakama, appearing for the applicant, had stated that on the same day itself, that is on filing of the application, the learned court allowed the said application and issued heirship certificate in respect of LSC number 17 of 1969 in favor of the respondent, namely Shri Zosan Zosan G Zua Rokhum Rokhum. The council submits that the said order was passed without any notice to the respondent, to the applicant, as well as other brother and sisters. Thereafter, full stop. Thereafter, full stop. On the same day itself, that is on 5/7/2023, the heirship certificate was also issued to the respondent by the learned court. Full stop. Since no notice was issued in respect of the said proceeding, the applicant and others did not know about the same, and only during January 2025, when a meeting was called by the wife of the respondent, after the demise of the respondent on 15/11/2024, they came to know about the heirship proceeding and the certificate. The said meeting was called by the wife of the respondent to present the will left by her husband, wherein it was alleged that her husband had, wherein it was stated that her husband had bequeathed all his property to his family members.
My Lord, may I make one small request? Instead of mentioning as bequeathed all his properties, can we mention the LSC number instead?
Has given the LSC,
yes,
17 of 69. Instead of bequeathed, you write okay. Say to his family members. The applicant, on knowing the same, Mr. Lal Fakauma states that the applicant, on knowing the same, he had given, you had given, those.
Representation to the.
And knowing the same, given submitted representations to the land and to the concerned authorities. Where was that? Page number?
Page 16, Annexure 2.
Concerned authorities in the Land Revenue and Settlement Department, stating inter alia that after the demise of the registered owner, that is their father, on 14/4/1998, the children were allotted their share as per the Lok Adalat Award dated 4/12/2000. It was also stated that as per the Lok Adalat Award, the land was distributed amongst the parties and they were enjoying the same. It was further requested to the said authorities. No, it was not further request. It was further stated to the said authorities that wife of the respondent had verbally informed them their intention to mutate the said land under LSC number 17 of 1969 in their favor on the strength of the will allegedly executed by the respondent. As such, a request was made to the authorities concerned not to entertain any application for mutation, of the said land without informing them. And where is that tax that you had paid? Yes. It is also the case of the petitioner that when they paid the what is that?
Property tax.
Property tax, right? When they paid the property tax on their share, when they tried, right? When they tried to pay the property tax on their share of the land by online, through online, what do you say?
Through
online, they came to know, he said, he came to know that the entire land was in the name of the respondent. Aggrieved thereby, the applicant met the councils with the intention to challenge the heirship certificate. Where is that paragraph where you had gone to the
Page 8.
9.
When you went to give the property tax, it was already mutated, right?
It was already mutated and it was shown as already paid.
Acha, that you write was in the that mutation thing, was in the name, and it also reflected that the said land was mutated in the name of the respondent, and the online tax payment was already made. Then what did I say last? Met her counsels and requested the advocate to check if any heirship certificate has been issued issued in favor of the respondent. And the advocate, after making necessary inquiry, informed the applicant that an heirship certificate has been in fact issued in favor of the respondent by order dated 5/7/2023. Full stop. The applicant, as such, informed her advocate to take necessary steps for filing for filing necessary application before the appropriate forum. And thereafter, the present application is, and thereafter, the advocate prepared the case, and as such, a delay of 535 days occurred in view of the said facts. Mr. Lal Fakauma submits that the applicants had no knowledge of the heirship certificate issued in favor of the respondent, and that they acquired the said knowledge only when the meeting was held in the month of February 2025 by the wife of the respondent. He also submits that before the online tax submission, before the online tax payment, before the online tax payment procedure, they used to pay the tax by going to the office, by going to the concerned office. And during the said process too, they did not know that the land was mutated land in respect of LSC 17 of 1969 was mutated in the name of the respondent. And when they had come to know, they had immediately made representation before the concerned authority and approached the council for taking necessary recourse to ventilate their grievance. And in the process, the delay has occurred. You are Mr.
Roshan Subedi.
Huh?
Roshan Subedi.
Roshan?
Yes.
Roshan?
Subedi.
Superi.
S-U-B-E-D-I. Subedi.
Superi.
Yes.
D-I.
Yes.
Mr. Roshan Superi, appearing for the respondent, had filed an objection to the said condonation application and had stated stated that when the heirship certificate case was filed, all the siblings knew about the same and that they all consented to it by raising no objection. And as such, he had submitted that the condonation application may be dismissed. The delay in filing the instant case may not be condoned. However, Mr. L. Fakama has submitted that in the said objection filed by the respondent, it is also reflected that it was on 30/1/2025 what did I say initially? Alpha comma? When the wife of the respondent had announced that they had obtained airship that respondent had obtained airship certificate shows that they had no knowledge before that. The petitioners, the applicant had no knowledge before that, as could be seen from the said affidavit itself. The reasons shown by the applicant in the interlocutory application that he had no knowledge about the airship certificate which was given to the respondent in the year 2023 seems to have basis. More so, in view of the statement made by the respondent himself in the objection that in the month, it was in the month of January that the declaration was made that the airship certificate was issued in favor of the respondent. It is also seen that during the airship certificate proceeding, no notice was given to the parties concerned, and as required under the law, no newspaper publication was also made. As such, it is not disbelieved that the applicants did not know about the same. In view of the discussions made above, this court deems it fit to condone the delay of the said number of 535 days in preferring the instant first appeal against the airship certificate, right?
Yes, Your Lordship. 911.
And the order dated
5/7/2023.
5/7/2023. The delay is condoned. It is already registered. Delay is condoned. The instant RFA may be taken up for. May be taken up for hearing or what? RFA will be taken up.
May I make one small suggestion?
For consideration.
Yes. May I make one small suggestion, Your Lordship? If notice can be issued in the main appeal.
Okay, this is in IA.
Yeah.
So the IA is disposed of. Then in the main appeal, you write? Oh, taken up, I didn't say, no, taken up by this court. The RFA may be taken up by this court. And in the main appeal, you write? Heard Mr. Lal Fakama for the petitioner, for the appellant. In view of the order passed in the interlocutory application, notice be issued. Oh, you are already appearing, right?
Yes, yes.
There is only one respondent? No, and two others.
Pro forma respondent.
Oh. 2 and 3, you are appearing? Okay. In view of this so-and-so, notice be issued to the respondents. Since Mr. Roshan Suped appears for respondent number 1, no formal notice is required to be served upon him. Ms. Lalrumpui appears for respondent number 2 and 3. However, extra copies may be furnished to them by the petitioner, by the applicant, by the appellant within a period of 2 days. List it after 2 weeks on a date to be fixed by the registry.
I'm deeply obliged.
And the other IA?
The other IA is
Bringing on
It's for
record.
stay, my lord. Bringing on record, come on.
No.
We can take it up in the next court date, Your Lordship. We can take it up in the next court date. This is for additional evidence in the appeal stage.
That will go along with your appeal.
Yes, I think we'll have to go together. Deeply obliged.
Oh. What happened to this petition? I kept it there. Yeah, I think I kept it here somewhere.
Item 21.
Item 21.
Your Lordship, we have received the paper book, so the matter may be put up for hearing in the ordinary course of procedure.
Okay, this is a matter under POXO?
No, Your Lordship, NDPS bail. Sorry, appeal.
NDPS. Paper book is ready?
Yes.
You have got it?
Yes.
You have also have. So, okay, we will fix our hearing on in the usual course?
Yes.
So, right, it is stated at the bar. Oh, heard Miss So-and-so? Your name?
Sarah Lal Pensange.
Okay. For the appellant? And Miss Mary?
Your Lordship, on behalf of the appellant. Can he not?
On behalf of?
On behalf of the appellant.
This is a regular appeal on behalf of B. Lalramenge?
Yes.
On behalf of Lalramenge and Miss Mary, learned APP. It is stated at the bar that the paper book is prepared and the same is served upon all the parties. As such, list this matter for hearing in its usual course.
Obliged.
Hearing list, item 1.
Good that there is one hearing.